Welcome back, everyone. Today we've got a high-stakes courtroom showdown involving probation violations, alleged alcohol use during pregnancy, and multiple missed tests. The defendant insists she's innocent, citing hand sanitizer mishaps at work, while the court has dozens of skip tests and previous felonies on record. Stick around because we'll break down every twist, from legal obligations to emotional courtroom moments. Who's telling the truth here, and what's at stake? Let's dive in.
How far along are you?
5 minutes.
She's consuming alcohol while she's while pregnant.
How?
You're 5 months pregnant. You have positive alcohol usage on August 3rd.
No.
Am I reading Mandarin? I mean,
That's
right?
according to the device. Yes, sir.
The device says that you're drinking.
That was hand sanitizer at my job, which I emailed my probation officer that day. It's not alcohol. That's why they took me out the register and put me on the floor to where I won't be around anything that consume alcohol, which is the hand sanitizer at my job. And I let my probation officer know.
Sanitizer dissipates in a matter of a second. Once you put it on and you're done like this, it dissipates in a matter of seconds.
But they write down all the registers and stuff. I have not consumed any alcohol at all.
That's not what this report says. Not only does this report say that you're consuming alcohol, you have excessive skips while you're on probation as well.
This part of the case is intense. The defendant claims she's never consumed alcohol during her pregnancy, explaining that hand sanitizer triggered a false reading. Meanwhile, the court highlights dozens of skip tests, each one a potential red flag. Legally, probation requires strict compliance, and missing tests can be treated as violations. Here, the tension isn't just legal, it's deeply personal, with potential risks to her unborn child. What would you do if your innocence hinged on something as subtle as sanitizer readings?
Hold on a second. Hold on. Okay, so April 4th, skip test. April 16th, skip test. April 18th, skip test. April 24th, skip test. April 25th, skip test. April 29th, May 2nd, May 15th, May 19th, May 22nd, June 2nd, June 4th, June 8th, June 9th, June 13th, June 16th, June 23rd, June 25th, June 26th, June 30th, July 2nd, 5th, 11th, 12th, 13th, 15th, 16th, 18th, and it goes on and it goes on as the day is long.
I was here on the 11th. I seen you on the 11th. We had court. And I said I work at the register, and I explained to my manager that I had to step away from the register to blow into my device. So as soon as they understood that I'm on a case to where I had to step away from the register, then they had allowed it to me because I have 3 hours of window to blow into my device. So I had got that handled, which I told my probation officer as well. So I allowed my manager to understand to where I could keep my job, to where she can move me to a different department, to where I won't keep leaving from the register to go blow into my device, so I will not be late.
Not only are you allegedly skipping, not only are you allegedly consuming alcohol, but you also have a prior DWI, felony DWI with a child from a year and a half ago.
Drug test, and I passed all my drug tests, so I'm just impossible because I have, and you can go to, and they took my blood test and my doctors as well too. So I have not consumed any alcohol during my pregnancy or before my pregnancy. And when I stood before you on July 11th, I have not took any alcohol at all. That's the honest truth. And I saw you on the July 11th. And then after that, when I had found out I was pregnant, they took my blood and everything. I have not consumed any liquid of alcohol down my throat.
We have clinicians that evaluate you to determine what the best course of action going forward on this probation is. They've deemed, after doing all their research, that the best way moving forward is to put you into a residential treatment program. I like to follow the advice of the clinicians because they know what they're talking about. Not only, are they saying this, but you're also providing us with evidence as to why it's a good idea. You're saying you're not consuming, but I have concrete evidence that you are, and I have dozens of skip tests when you're not supposed to be skipping.
What
I
day
know.
that was said I consume alcohol? Because that's the day that I emailed my lawyer that day and I was at work.
It's not a negotiation. I'm just, that's what they're recommending, and I think that it's a good idea, you know?
So that means I go 45 days, I lose my job, I lose my apartment, I lose my kids, might end up having a miscarriage because I'm in there for 45 days for something that I did not do. That's the reason why I'm back, because I have not.
So just the only other thing I could offer is maybe Santa Maria. Have the clinicians considered that? Did they know she was pregnant?
The recommendation was a community residential program followed by social care.
They didn't recommend Santa Maria. Did they know she was pregnant?
What's the difference of Santa Maria versus?
It's an outpatient drug residential facility treatment center for pregnant females. It's only pregnant females. She can get a bed there reserved for her, but they have to accept her into the program. It's common in felony with pregnant women, but I don't know what it's like here in misdemeanor if they even offer the Santa Maria Hospital, but it's supposed to help pregnant women.
Are you married? Who's taking care of the other kids?
Me.
You don't have any other person in your life?
Boyfriend, but I mean.
Okay, so you currently live with your boyfriend?
Mhm.
So he's got, you know, possession of the apartment, I would imagine as well. So you're not going to lose your apartment.
Almost in my name, not his.
Okay, I mean, as long as the rent is being paid, you know, but my concern is that you're not consuming alcohol, especially while pregnant, because if you do, you're ensuring a lifelong potential problem with that child. I have evidence here that you're consuming alcohol. I have evidence here that you're refusing to blow into the machine like you're supposed to. And that's why we do these. Recommend.
I'm so sorry.
I know that you don't like it, but I'm sorry.
No, because I can't just stand here and just, I can understand the skill part, but the actually consuming, drinking alcohol, I can't stand here. And that's on everything I love. I have not consumed any alcohol since you put me on probation. Since we had this last conversation, I have not put a risk.
To prove to you otherwise.
Jeremy must have alcohol in there. So it's like y'all saying that I actually took a cup. I actually put it to my mouth and I actually drunk the alcohol while I'm pregnant. I can't stand here and let that go by and feel like that's okay, because I knew I have not. And I emailed my probation officer when it happened, when it violated on my device. I'm just messing with I'm sorry. I'm just trying to get him understanding.
I understand that you're upset.
I literally emailed her when the device was violated. When it said violation, I was at work on lunch trying to catch it before 8 o'clock. And that's when it said violation. So I'm trying to figure out, we have hand sanitizer everywhere on the registers. So that's where it came from. It have not come from no alcohol.
It's not hand sanitizer. Hand sanitizer doesn't go into the actual tube that you blow into. I mean, I'm sorry if you.
Your Honor, would you consider if she meets the requirements for this Santa Maria outpatient?
Of course.
Would you be?
Outpatient?
Yes, Your Honor. In light of the fact,
she's been on probation. We've given her the opportunity to do it on her own, and you're not doing it. So that's why we have this now as the alternative. And I always tell everybody, look, I will give you the opportunity to try it yourself. If you're unable to do it, then we're going to do it my way. And I know that you're not going to like it, but that's the reality. The reality is that we don't want you to consume alcohol, especially while you're pregnant. And I've got evidence to the otherwise. And so the only way is to do it our way. I know you don't like it, and I'm sorry, but that's the reality.
Your Honor, if I may, can I have the date that you say that she tested positive for?
Here, I'll give everything to you. If you want more time to take a look at it, just you guys hang tight, go take a look, and we can come back up here and talk. Don't leave. Otherwise, I'm going to issue a warrant.
Yes, sir.
Francisco Negrete. Mr. Negrete, you're charged with racing on a highway. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On October 20th, 2024, officer observed two motor vehicles traveling on West Grand Parkway in Harris County, Texas. Officer observed the motor vehicles positioned side by side, slow to pace. Then one motor vehicle sped off excessively, then slowed to a speed where both motor vehicles were side by side. The officer observed this on 3 occasions. Officer observed both motor vehicles come to a stop at an intersection, roll down the windows, and appear to communicate. Officer observed both motor vehicles rev their engines and speed off excessively when the light changed. A traffic stop was initiated and one motor vehicle sped off. Officer made contact with the defendant. The defendant stated he did not know the driver of the other motor vehicle. He intentionally placed the motor vehicle side by side with the other motor vehicle and stated, "We were rolling," when asked about the purpose of the position. The defendant stated they wanted to find out which car could go faster. He has an eligible driver's license.
Do you have any kind of indication as to how fast they were going? Were they,
I'm looking, Judge. Checking to see if we have the offense report yet, but it doesn't say it in the dim.
Mr. Negrete?
It doesn't say, Judge, I'm sorry.
Mr. Negrete, I'm going to find it probable cause to go forward with your case. I am now putting a condition on your bond not to participate in any racing, street takeovers, donuts, or reckless driving. If I find that you do this again, I will take away your privilege to drive. Do you understand? Living in a city as big as Houston without the ability to drive is an awful thing. Do you understand there are proper places to do this? 610 or 59 or the tollway, that's not the right place. It's now a condition of your bond. Do you understand? Are you a citizen of the United States?
No.
Are you in this country with or without permission?
With permission.
I don't know if you are or not, but if you go to jail and you're not in this country with permission, or if it's expired and immigration finds you, they will put an immigration detainer on you and you will be stuck in custody until the case is over with and then shipped off to immigration. Do you understand?
Yes.
Can you file those conditions, no racing and et cetera? We're going to reset your case to give you time to hire a lawyer. So first I'm going to have you go to Victoria, sign a reset. Wait a second. You have a Texas driver license?
Yes.
Do you have liability insurance in your name?
Yes.
Okay, you said you ran a license?
Yeah, it's eligible.
Okay. So I'm going to have you sign a reset, Victoria. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it and then we'll send you on your way. When you come back, please have a lawyer.
Right this way.
I wish I could make that coat work for me.
Good.
I wish I could. You know what I'm saying? I can't.
Well, let me tell you, we're not very impressed with Miss Martinez, I guess, huh? Is she here?
Well, they are semi-impressed.
Is that her?
Yes.
Come up, Miss Martinez.
The district attorney has recommended that they extend it, with your permission, 3 months to prove and demonstrate that she can comply with the requirement. She's done everything else. She didn't ever test positive. She just had
Just didn't test.
3 skips and 6 late. That's where she's at. And the CLO was kind enough to give me that information. I asked her if that was her hat over there. She said no.
It's my hat.
Okay.
Yes, so that he's correct. She's completed all of her required classes. She's current on her feet, so she's averaging 4 to 15 skips per month. So they wanted to extend her for 3 months.
Now, the judge is imposing a SCRAM device, essentially monitoring every drink through a continuous alcohol sensor. This is no small thing. Failing this could mean immediate trial. The court is balancing the defendant's rights against public safety and fetal health. It's a classic example of the system pushing for accountability while giving a second chance through outpatient treatment. This is a critical moment. She must prove compliance to avoid harsher consequences. Can she manage the strict oversight and keep her life on track?
She'll have to get a SCRAM. But I will give it to you. She's gonna have to get a SCRAM device so we know. No more skips. Now you must get a SCRAM device, ma'am, so that we know that you're not consuming alcohol. We can't trust you with the device anymore. So we're gonna order you to get a SCRAM device, and then we'll give you the 3-month extension. If you test positive, it's over.
Do I return the device that I have currently? Or how does that?
I mean, I'm okay with that. Yeah.
And Your Honor, may it please the court, I think she's in school. She's a college student right now. That's a pretty significant expense. Do you think we might be able to either waive it?
I can if I would. I don't know if I can. I don't think so.
I also have other cases on top.
What do you mean
Domestic.
other cases on top?
My ex-partner assaulted me in February, so I'm also dealing with that. And CPS, he assaulted one of my kids this past August. So I'm also dealing with
You
those.
separated from this person or you know?
Yes, no, we're separated. I have a protection order now.
Just stay away. And, you know, it's not the end of the world, but you have to understand that when you have an open case, you know, your partner will use it against you as leverage in CPS cases, in divorce cases, in custody cases, and that's what they do. So you got to be careful. Don't give anybody leverage so that they can use it against you. You know, this is the opportunity that you have, and it's a very great opportunity because if you complete it, the case gets dismissed, and now you're here because you have violations. I'm going to tell you now, it's no tolerance.
Your Honor, may it please the court. Could we, and I understand it's expensive to get that device. Could we set it for, say, if she gets it and then in a month, see how she's doing? Because I mean, she's just struggling as it is.
I'll have it with you. Half the time, a month and a half.
Okay.
No skips. She's doing well. We'll come back. She'll have to have the other device.
Okay.
And then I'm down with that, Mike.
Thank you very
But
much.
like I
Your Honor.
said, any positives, and I don't care what it is, there's absolutely no tolerance now. I will not give you anything positive, I will not reset your case anymore, and I'll immediately set your case for trial. You understand? There's just no excuse. If you need to find an outlet, if you are, you know, having a rough time with life in general, there are other releases that you can use. Alcohol is not a good one.
She's, and as I said, she has to modify her behavior so that she tests within the period of time. I mean, they're not indicating so far that she's tested positive. She just.
Oh, we don't have blows to prove it. And that's
I understand that, and that's all the evidence we got.
when you don't test, we make assumptions, and the assumption is that you're drinking, and that's why you don't want to test.
Some of those, I can say that there was a couple of them that were late, not on time, but I did late because my sleep schedule has been off due to college and dealing with, you know, the cases.
The judge he's made the
You
decision.
don't have to
We
say
have to have it for 45 days. And
you don't. We make assumptions, and
so where does she go to get that? Okay,
so Mike, halfway, she's good, then we'll.
thank you. You have a great day.
Thank
All
you.
6 weeks, Jen? 6 weeks?
I have Wiggins.
Lindsay, I'll hit you next.
Wiggins is the one that Anna is on, so I asked your clerk to put the motion to appoint second chair in your queue.
Fine.
He's set today. Anna wants him set Monday to address.
Have Wiggins?
Yes, he is here.
Bring him out.
So I spoke with, it takes me everything to not say the word Mikey, with Mr. Haddad.
Why?
Well,
You normally don't know.
That's what Munir calls me.
I guess it's a term of endearment.
It is a term of endearment. That's why I let him call me.
it is a term of endearment. I just, like, I try to have some level of respect and not do it while at the bench. But I spoke to Mikey, and
It's Chief Mikey.
Chief Mikey.
He's busy chiefing, Judge. So the jail calls exist in two separate computer systems. So they do exist, and a DA has listened to them, but their ability to listen to them is separate from them having their ability to share them. So they have requested the files be duplicated, and that has not happened. So they do exist and they confirm and they listen. We don't have copies.
Have you listened to them?
We don't have them yet, Judge. They've been requested. They have not been uploaded.
But have you listened to them?
No.
So,
To my understanding, can I listen to them before they're?
and speaking of Mr. Haddad, there was a note from a prosecutor that had. So,
I just want to know if it's true.
so third person hearsay for Mr. Haddad, yes.
So Judge, there's a software called Virus in which the state can listen to all jail calls made by Securus and Tribunal, but we don't have them in our possession until they're requested. I just saw a note from a prosecutor that they may have listened to a call, but that's, like Munir said, it's hearsay. I don't really know if that's true. I just know that we have requested them last week, but they're not in the portal for the defense to access quite yet.
Who listened to them?
That was the deputy or the investigator last week who made the phone call. I think the felony prosecutors.
So can they confirm what the allegation is? Because I don't want to keep him in ag seg if he didn't do it. I want to put him in gen pop if he's been good. But if he's not,
I will say ag seg versus gen pop, not gonna change the safety of the victim. Change the level that she can be annoyed by potential phone calls, but he's not going to be able to harm anyone over the phone.
I mean, Judge, we
you don't
haven't.
know that though, because who knows who he's calling, who knows what he's saying for something to get done out there while he's in here.
I
So
don't think
there's
there's
no,
any allegations of him speaking to a third party about any of this.
Well, Judge, even though we may not have personally listened to them, we have the complainant that she's the one that reported it to begin with, that she was receiving the threats from this defendant. That's how we know, Judge.
how long until I get the actual phone calls?
Her request last week.
So, Judge, they usually take a couple weeks to actually get them to evidence. I would say 2 weeks.
I'm trying to get the phone calls as quick as possible so that we can verify what the allegation is.
Don't speak, don't. No. Don't question.
I'm just telling you, from the last hearing that we had, what the allegation is.
I'll speak to,
The complaining witnesses also come forward to verify that there have been threatening phone calls.
I can give you a
So-
recitation of the facts, not in front of all of these people. So I'll talk to you about that in the back.
When we mean no threats, we mean no threats. So understand, I'm trying to get it as quick as possible so that we can move forward. I don't want to keep you in ag seg if it's not true, right?
I know Miss Edie wishes to address the segregation unit inside the jail. I believe she wishes to do that on Monday. She's of course at a training today.
Yeah.
Okay.
He
All
did admit to calling the complainant when he was before the bench last week. I have notes in here that he admitted that. He just said, I was.
Can you get them as soon as humanly possible so we can make this definitive one way or the other,
Yes,
please?
Judge. They were immediately requested.
Do you think that we should subpoena the officer here? Would that make things go quicker?
No, Judge, I mean, generally, the jail has received our requests. It just takes a little bit of time because generally these are hundreds, thousands of calls that they have to put on the portal, Judge. It takes time. It really we just need a little bit of time. That's it.
My understanding with my conversation with Mr. Haddad is that they can be listened to by the DA now. So if you like, we could send somebody, I can go with the DA and the.
Listen to it too?
Well, yeah, Judge, the problem is, again, there's thousands of these calls most likely. So to actually get to the call where we know the threat was made is going to take a long time. We need the investigator to give us the date and time.
Imagine the logistics of trying to identify the phone call, the time.
Well, my understanding is it's like a filter. You just put in either the time and date or even the number dialed. So I think you would have the CW's number.
We put it off for one more week since it's already been a week?
Can we do 2, Judge? I think if we do 2, I mean, it's not gonna, and if we get them beforehand, Conrad will do his due diligence. He will contact Munir. We can get it on the docket earlier than 2 weeks, but I don't want to keep putting it on when Mr. Wiggins is not gonna get anything out of it.
I want to send Monday to address the SEG because while I'm here and speaking confidently about one thing, Miss Edie is going to speak confidently about another, which is the segregation, and I have no information about how that works. And I know she wishes to have a conversation with the court. So I'd ask to keep them on Monday.
Yes.
And assuming that they can listen to them, figure out how, perhaps we can all go into a room on Monday and do that very quickly.
Let's see.
Yes, Judge.
If you can, wonderful. Let's try it.
All right, thank you.
Okay. All right. Mr. Wiggins, we'll see you Monday.
Thank you.
Hi, guys. Nathan, anything else you wanted to talk about?
I've got another client who is considering pleading. And if she makes a decision to plea, I might have to preview it to you to make sure you would accept. Last name Kurtz, K.I. Nolan Kurtz, his last name.
Is it a DBI second?
No, it's a first, PTI, she was unsuccessful. She was on
I'm
it for
okay
some
with
time.
it. You want time served?
Yeah,
I'm okay with it.
okay. She's still
As
considering it
long
now.
as it's not like a second.
No, it's not a second.
No,
She's considering it
Just a-
now.
she's in PTI now.
She was just kicked out of it.
She was kicked out.
Yes.
They don't want to keep running. No.
No, she tested positive once, I think in March, had a traumatic June, admitted to consuming alcohol in June after being placed on zero tolerance, and then there were some skip tests on the blow and go.
Okay. You guys tell me what you want to do.
Well, she's making a decision now. So,
If I'm going to set up a trial.
well, and that's her decision, is to either plea or
So
settle.
what? Kurtz, you said with a K?
Nolan Kurtz. Last name is both Nolan and then Kurtz. Is that?
Oh, it's 565. So it gets like a very short.
Yeah, yeah.
Just tell her it's a short trial setting.
So, I don't know grammar. What is a straight line?
A hyphen.
A hyphen. So Nolan hyphen Kurtz. This shows you how much I paid attention in English.
Washington?
So
What do we owe the honor of El Famoso Arnold Lopez?
No, Judge.
I mean, really?
You're the famous one.
No, it's you.
My son sends me videos of you from Chicago.
Oh, wow.
Really?
No, I had a person reach out to us from Israel yesterday. I'm like, wow, crazy, huh?
You're famous.
No, whatever.
When I told my dad I was starting in this sport, he was like, Judge Fletcher, I've been watching him. So my dad has been watching you apparently for a few months.
Wow.
Judge,
Judge,
you see me on it.
Judge, I'm on, well, actually, one of my lawyers is on,
It's a bond violation. right?
yes, he is, Judge. But we reached an agreement. But only, can we reset it for a week or so I can get the lawyer to come?
What's the name?
Pedro Morales Velasco. It's just that I have another pressing issue going on.
Morales. Hey, I don't, is it, I don't,
Yeah. We used to.
is it under Velasco?
Just a week or so, Judge.
I've had a lot of problems with this guy, man.
But you won't have any,
I'm blowing positive. He's drinking.
you won't have any problems anymore, Judge.
Come up. Velasco Morales.
He's also a Spanish speaker, Your Honor.
Let's just go.
Let's go, but I need to get back in the box anyway.
No, hold on.
Okay, he's a Spanish speaker, so
Come on. ¿Qué te dije que no puedes hacer? ¿Qué te dije que no puedes hacer? ¿Qué hiciste? ¿Qué pasa ahora? ¿Qué pasa ahora?
Eres en la cárcel.
Right, goes with you. No. Yo te dije.
did mi esposa. Judge, we were getting a plea today, after all. We had a probation plea on it. We can do it today, Judge.
But he's blowing really high. And it's
Judge, if we can't possibly work it out with the,
I'm happy to do it.
let's work it out today, okay?
Okay, we can take him for now and then we'll let you, whatever you want. Yeah.
I'm approaching Mr. Hubler. He's in the jury box. He tested negative today, so that's some good news. And he's also checked himself into an inpatient drug rehab program with Salvation Army. And Mr. Hubler, Judge, I'm sorry, he's right there in the jury box.
Send him for a drug test, right?
Yes, Judge, he tested negative.
Come up, Mr. Hubler.
And Judge, I have an agreement with the state where if he completes that drug treatment program with Salvation Army and also gets employment and some residential information, that they'll dismiss the case. And so,
Good job testing negative.
so
Great. That's all we're asking you to do, man. Stay clean. That's all. I'm not asking you to split the atom here, you know? When you're clean, good things happen, you know? The other thing is this, is that you've taken off on us.
I did, sir. I didn't have a way.
Judge, can I explain that?
Here.
Sure.
Judge, he was in Tomball at the time. He had no transportation, and he had, isn't that right, Mr.
Yeah,
Hubler?
I was homeless.
So today he walked from Salvation Army to here for court, but he just had no transportation, Judge. And he let me know that before court, that he couldn't get over here.
There's no.
Why are you homeless?
Man, I screwed my life up. I had 3.5 years clean and sober, and I got.
All of a sudden you boom homeless? That doesn't happen.
No, I left the place up. My friends I was staying with, they were back on drugs, and we got into a big argument and fight. And
what do you have in your life now?
I have my family. We're just being. I know I was on drugs. My family doesn't accept that.
Good, as they shouldn't.
Exactly.
I don't want someone who's in my house all doped up. They're just, you know, when you're in a state like that, you're very vulnerable, right? You get angrier quicker. You have no patience. And the people who suffer the most are everyone around you when you're using. And it's not fair. And it's not fair for them to have to live with that kind of fear. Oh my God, is he using? What's going to happen today? Is he going to beat me up? Is he going to? No one wants to live like that. So it's only natural. You know what I mean?
I chose to be homeless in a sense. I pushed away from them.
Yes, of course.
I still have my family, thankfully. Now, since I did have clean and sober before, I got them back in my life and I pushed away. So
where are you living now?
Right now, I'm at the Salvation Army.
Why don't you go back home?
I want to finish this program. I want to get it right this time.
It's a 6-month inpatient drug treatment at the Salvation Army, Judge. And then he's planning to do a transitional living.
Yeah, to make sure I get it right again. Because I did it before and I had 3 years clean and sober, and I got injured at work. And I didn't think I was going to get my hand back. I had 3-4 surgeries to get my hand back functioning.
Cognizant that you have a very, very addictive personality.
Sorry.
So when you get injured, even if it's something catastrophic, if they prescribe you painkillers, you need to have the wherewithal to know, okay, I can't take this. I'll take 4 Advil, or you take Motrin, something else, because you can't take benzos. You can't take it because it's just going to spiral out of control. There are a lot of people that they can take one and be done with it. And then there are others that,
I'm not one of them.
right. So what do we do?
So Judge, can we get a little bit of a longer reset so he can keep doing that program with Salvation Army, and then maybe we can.
I don't know, because I want to make sure that he's clean and sober, and I need to know that he's not using while he's out there. So I'm happy to give you a reset, but longer, I don't think that that's a wise thing.
Do you want to drug test him in 30 days, Judge? What is your thoughts?
Do they drug test me randomly there all the time?
How long of it, for this to work out for a dismissal, how long are we talking?
It's a 6-month program he's doing, and then he's going to the transitional living facility.
Yeah, and
there he's planning to get employment, and I think that Michael wants proof of some sort of employment after he completes it.
You know, Michael, I'm on board with you. I think it's a great opportunity to dangle a dismissal for proverbial sobriety, right?
Sure.
But I think that, number one, we need to know that he's enrolled, because how do we know that he's enrolled? Other than his.
I can get some sort of paperwork.
Could you text that documentation to me, and I can give it to the judge?
Yeah,
Here.
Can you write your number down? Because I don't have my cell phone. They take your cell phone for.
In life, you're only as good as the proof that you have. If you don't have proof, you don't have anything.
I understand.
I'm not going to take your word for it. Like, I don't take anybody's word for it. I need proof. So, and I think that.
Judge, I will say I am proud of the defendant, because this is the way he presents himself today. So different from his arraignment. It is so different. And I know he fled a couple times, but I think this is all stemming from his lack of sobriety. So this is why I made the offer that I made in this case.
Good things happen when you're clean,
Yes,
right?
sir.
So let's do this. Let's set this off just a couple weeks. 2 weeks. I need proof that you're in the program. I need you to get it to James. don't flake out on us again.
I won't.
Because if you don't, no more PR bonds. You understand? So if you can show me the proof that he's actually enrolled before the next reset, I'll waive the appearance.
Yes, Judge.
Okay? And then you stay in the facility, just take it day by day, get it done. And then from there, we'll do like 30-day resets to make sure that he's in compliance with the program. He's still in it. If it gets too long and you get booted out or you're not doing it, I'm going to set your case for trial. So just stay with it. Good things will happen for you. Okay?
Thank you, Judge. I'll get a 2-week for now.
Good job, Mr. Okay, for sure.
To wrap up, today's cases showcase the complexities of probation, drug rehabilitation, and personal responsibility. One defendant navigates strict alcohol monitoring and SCRAM devices, while another is enrolled in a 6-month drug program with transitional living support, showing the court's dual focus on accountability and rehabilitation. The key takeaway? Compliance, proof of enrollment, and consistency matter. Courts aren't just punishing, they're incentivizing change. If you found this case as shocking as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.